They're just trying to figure out where to go. They're all they're good. Okay. rise. Court's back in session. The Honorable Semmie Williams presiding.
Good morning, everyone. Happy pre-Friday to you. Please be seated. Mr. Williams is present. Good morning, sir. Mr. Williams. So we have all the jurors. Do you want to release Fisher? I don't want to use her. Well, I'll use her name. Fisher, Morrison, Youngman, and Korma. I think that's what's appropriate. And then just proceed and swear in the official jurors. Correct. With the four alternates. Right. The names that I read were the last four alternates that we kept as a cushion in case. Agreed. Yes. Mr. Williams?
Hey, how you doing?
I'm good, sir. How are you?
Okay.
All right, we're ready to start the trial. As you remember, yesterday, because there was an issue with not being able to contact some of the alternates, we had a backup plan for 4 additional alternates in case those individuals didn't appear. Remember that? So now everybody has appeared, so we have 4 extra jurors. I'm going to excuse those extra jurors and then swear in the 12 and then the 4 alternates. Okay?
Appreciate it. Okay.
You still satisfied with the jury selection process, sir?
Oh yeah, we just got just one extra guy yesterday, right?
We have everybody. We didn't lose anyone. So now we're going to excuse those 4 extras that we talked about late yesterday.
Okay, I'm fine with that.
Okay. And you're still satisfied with your attorneys?
They just have a history of telling me.
Right, but right now, we're not talking about the history. We're just talking about during this trial process. Are you happy with everything that's trained?
Yeah, they do a pretty good job sometimes, yeah.
All right, and so far you're satisfied with how they've handled the jury selection process, sir?
Yeah.
Okay. I'm going to bring in the 4, release them, then bring in the what would be the official panel, and then have them sworn in. Okay?
Okay.
Deputy, would you please bring in, where is he? Thank you. Fisher, Morrison, Youngman, and Korma? Youngman and Korma. Khourma. Thank you. Yes. Counsel, you got your IT issues resolved? Yes. Okay. Are we bringing in the floor? Counsel approach. We're taking a break. Counsel?
Judge.
No, I'll talk to you in a minute.
Yes, Judge.
council approved. We're in recess until 10 o'clock.
Court's in recess. Come to order, court's back in session, Honorable Semmie Williams presiding.
Good morning again, everyone. Please be seated. Council approach, please. Council approach again.
Jurors in the courtroom.
Please be seated. So I just want to make sure we have the right individuals. Fisher, Morrison, Youngman, Korma. Okay. We are excusing you from further service, but I do want to thank you profoundly for your time, attention, and consideration in this case. I know it's been a long couple of days, and I know there's been a lot of fits and starts, but you are truly the fabric, and we are truly grateful for your participation and willingness to serve. One of the deputies, will you escort them to the jury office for them to give their badge, and then they're officially released?
Yes, Your Honor.
Thank you. Corporal, once these 4 jurors go, then bring in the rest of them. Thank you. before you're seated, I just want to make sure you're all seated in the proper places. So just stand for a moment, and then we'll make sure that you are where our map says you are supposed to be. I'm going to use your last names. Firth, Hurley, Howard. Once your name is called, you can have a seat. Santana, Butala, Ellison, Tartaglia, Patterson, Bradley, Sanchez, Ruffalo, Bissennett, Thomas, Hanson, Simpson, Needle. Thank you. Madam Clerk, would you please swear in the jury?
Raise your right hand, please. Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant Semmie Williams and render a true verdict according to the law and the evidence? If so, say I do. I do. Thank you.
Thank you. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Semmie Lee Williams, Jr. This is a criminal case. Semmie Lee Williams, Jr. is charged with first-degree murder with a weapon. The definition of that crime will be explained to you later. The state's charging document, which is called an indictment, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Semmie Lee Williams, Jr. in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have an opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with final instructions. After the final instructions are given, the alternate jurors will be released, and you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instructions on the law by the court. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or the lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about the case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of these rules, notify court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell him or her that you are on the jury trying the case and ask the person to stop. If he or she persists, leave that person at once and immediately report the matter to the court deputy who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means the phone or other electronic device is actually off and is not in a silent or vibrating mode. You may use these devices during recesses, but even then, you must not use your cell phone or electronic device to find out any information about this case or communicate with anyone about this case or the people involved. Do not take photographs, video recordings, or audio recordings of these proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside of the jury room. While you are deliberating, you cannot have in the jury room any cell phones, computers, or other electronic devices. While you are deliberating, if someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact number has been provided to you. The case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the court. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic devices, or any other means at all to get information related to the case, the people or places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family member make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the court will have no way to make sure that the information you obtain is proper for this case. The parties likewise will have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and to challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court, face sanctions, such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it was made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys about the case out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. If you would like to take notes during trial, you may do so. On the other hand, of course, you are not required to take notes if you don't want to. That will be left up to you individually. You have been provided a notepad and pen for your use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the court deputy will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the court deputy will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. The attorneys will now present their opening statements if they wish. From now on, each side has equal time. The state has the burden and therefore starts first. Is the state giving an opening statement? Yes, Mr. Clousey, are you giving the opening statement? Yes, you may proceed, sir.
Your Honor, ladies and gentlemen of the jury, good morning. May I proceed, Your Honor?
Yes, sir.
Thank you. No matter where someone may live, random violence can still live there too. And when it strikes, it can strike with brutality and with purpose. And whatever sparked it to occur can never excuse it. Random violence struck down 14-year-old Ryan Rogers on Monday, November 15, 2021 at approximately 7:30 p.m. when he was attacked, stabbed, and left to die in the woods, in the dark, near Central Boulevard and I-95 in Palm Beach Gardens, Florida. 1.5 miles from his home. 5 minutes left on a bike ride that he will never get to finish. What the facts and the evidence throughout the course of this trial is going to show that the man responsible for that violence, the man with Ryan's metaphorical blood on his hands, and as we will see through the facts and the evidence, Ryan's actual blood in his belongings, is that man right there, Semmie Williams, the defendant in this case. The reason he is sitting in that chair is because on November 15th, he committed the crime of first-degree murder with a weapon. Now, Ms. Walensky has been running the show, as she should, but as she mentioned, my name is Richard Clousey, and along with her, we're proud to represent the state of Florida as assistant state attorneys. And as the judge has mentioned, as we have talked about, as defense has talked about, and I will say again, there's one table in this room that has to do the proving. It's the This one right here, nobody else. We know that burden. We embrace that burden because we are going to meet that burden. So ultimately, what do we have to prove? First-degree murder with a weapon. Now, the judge has told you, she is the law, okay? She is the law. She will give you the law. She's given you laws already. She will do so again at the end of this trial, and you'll bring the law back with you when you start your deliberations, okay? But since we're the prosecution, we have to know in advance what we have to prove to you all. And in essence, what we have to prove to you all are 4 things. Number 1, a person is dead. In this case, that person is Ryan. We will prove that beyond a reasonable doubt. Number 2, the reason that he's dead is because of the criminal actions of that man right there. We will prove that beyond any reasonable doubt, that he had no reason to kill Ryan, and in fact he did. Number 3, we have to prove that when he killed Ryan, he did it with premeditation. Now, you all were spoken to that at length. I'm not going to do it again, but you'll hear it again at the end of the trial. But in essence, what we have to prove is this defendant thought about killing Ryan, and then he did so. And the facts and the evidence are going to show he had that thought, and he carried it out over and over and over and over and over again. Lastly, number 4, we have to prove that when he killed Ryan, he used a weapon to do so. And again, we will prove that beyond any type of reasonable doubt. So, for those of you that maybe are unfamiliar with this process, the question might be, well, State, how are you going to do that? The way we're going to do it is we are going to bring people that back in 2021 had knowledge and information about how all this took place. It's going to be a bunch of people from a bunch of different walks of life, just like all of you. We're going to have civilians come in. We're going to have law enforcement detectives come in. We're going to have crime scene investigators come in. We're going to have cell phone analysts come in. We're going to have doctors come in. All of them are taking time out of their day, out of their responsibilities, to come in here and give you information that they have. They're going to go under oath and tell you what they know about November 15, 2021, and the events leading up to this defendant's arrest. So in essence, how are we going to start? Now, you're going to see throughout the course of this trial that maybe at certain times, Ms. Walensky is going to leave the room. I might leave the room. We might be on our phones. We might be on our computers. We can promise you we are not doing social media. We are not abandoning this case. We are trying to coordinate all of those people that are going to come before you to relay that information as efficiently as we can. So the most logical starting point when we talk about this case is what exactly did happen on November 15, 2021 with Ryan. And so one of the first people we're going to hear from is Ryan's mother, Cynthia. This will not be an easy thing to do, as all of you very well can imagine. She will come in. She'll tell you a little bit about who Ryan was, regular 14-year-old kid that liked riding his bike in a safe neighborhood in Alton and Palm Beach Gardens. She'll come in here and tell you that on November 15, 2021, it was like any other day. Ryan wanted to go on a bike ride in the neighborhood. She had no problem with it. Why should she? No reason to live your life in fear of random violence, or else a 14-year-old boy never gets to ride his bike without his mom. And I can tell you right now, I would never do that. So, no fault of hers. She lets him go have some fun. What you're going to see through the evidence is approximately 6:39, 6:40, and you'll see a grainy kind of surveillance video from their home. You'll see Ryan get on his bike and head out on that bike ride. 7:30 comes. Ryan's not home. No call, no text, no nothing. 8:30 comes. No call, no text, no Ryan. 9:30 comes. No call, no text, no Ryan. It's at that point that Miss Rogers knows something is wrong. And what we're going to hear her say is that her motherly instinct kicks in, as it would, and she reaches out to law enforcement to let them know, my child is missing. I don't know where he is. We're going to learn through the testimony that law enforcement jumps into action. It's 10 p.m. now at November 15th, at the earliest, that they can try to start searching for this boy. And they do. We're going to learn that they're trying to ping his cell phone, that they can whittle it down to a 2-mile radius based on how that technology works. But a 2-mile radius is still a big place to search, especially in the dead of night. So we're going to learn that they tried, but law enforcement does not succeed. But what we're also going to hear from Ms. Rogers is she not only engages the law enforcement community, she engages her own community as well. In today's day and age, social media can be used for bad. This is a time it was used for good. She posts to social media, in essence, saying, my son is missing. Can somebody help? If you see something, can you let us know? One of the people we anticipate you're going to hear from is one of those people that saw that message. And while we live in a world that does have random acts of violence, it also has random acts of kindness. Mr. Lindahl decided on the morning of November 16th, when he saw that social media posting and he lived in the area, said, hey, I ride my bike all the time for exercise. I know the area. Let me see if I can find something. And find something he did. He's going to tell you all that that morning he rode and rode and rode and looked and looked and looked and looked until finally, when he came to that intersection of Central Boulevard and I-95, when he looks into the wooded area of the bushes, he sees a bike that looks an awful lot like Ryan's bike. And he's going to tell us that when he gets closer to this wooded area and starts looking down the hill, what he also sees about 4 to 5 feet away from that bicycle is Ryan's motionless body. Now, Mr. Lindahl will tell you he's not a detective, he's not a doctor, he's not a CSI. He's not the type of person that wanted to disturb that type of crime scene. He knows how important that is. So that the experts, the professionals, can come and figure out what actually happened. So what we'll learn from Mr. Lindahl is as soon as he sees that, he does not disturb anything, he stays there, he contacts law enforcement, and they respond immediately to preserve that scene. So, just from those two witnesses, what we're going to learn is what happened. Because once the police officers arrive, crime scene investigators arrive, they confirm that, in fact, yes, Ryan is no longer with us. So just from those two witnesses, we're going to learn what happened. Ryan left his home on his bike, went missing, found dead. We're going to learn where it happened. Central Boulevard and I-95, the overpass. We're going to learn approximately when it happened. It happened sometime between November 15th, 2021 at about 6:40 p.m. and Tuesday, the 16th at 9 a.m. when he was found by Mr. Lindahl. So now the question becomes, well, how did Ryan end up like that? That's where law enforcement is going to start to get involved in terms of their testimony. People like Detective Brashear of the Palm Beach Gardens Police Department. People like CSI Cohen. People like CSI Olsalski that all responded to that scene and started doing various parts of investigation, such as preserving Ryan's body. So an autopsy could be performed and we could get down to why he was no longer living. Taking all crucial pieces of evidence from that scene, preserving them so they can be photographed, so they can be DNA swabbed, so they can be tested, and then put the whole picture together later. You're going to hear from those people and they're going to come in and testify as to their role. But what you're going to hear initially is that this was not an immediately apparent first-degree murder. That based on the injuries they could initially see when Ryan's laying face down in the grass, it could have been just some type of tragic bike accident. It wasn't necessarily murder. But they still preserve what they can to get to the bottom of it. So in terms of the how, the reason we find out is through Dr. Heidi Reinhardt, the medical examiner that performed Ryan's autopsy. We're going to learn that once she took custody of that and started going through the layers of her analysis as to why Ryan died, it became clear rather quickly this was not a bike accident. This was a homicide. As she starts to see Ryan's head and sees injury after injury after injury after injury after injury after injury after injury. This was clearly intentional and done by someone else. He was murdered. In addition to when she looks at his hands and sees his left wrist slashed and his right hand with 2 puncture wounds clean through his hand. Ryan did not stand a chance against whoever decided to kill him that day. So now we know the how. So now the focus becomes who? Who did this to Ryan? That's what Detective Brashear is going to do. She's the lead on this case. She is the director of the investigation. She's going to talk about how civilians with information, after they learned that this terrible thing had happened, started giving information to law enforcement. One of those people, Todd Blair, another citizen, he's going to tell us that in the early morning hours of November 16th, he was in the area of Central Boulevard and I-95, taking his normal morning walk. When he's there, he notices a pair of sunglasses just laying on the ground. Like some people that find a lucky penny, finders keepers, doesn't think anything of it, picks up the sunglasses, say, hey, cool, found some sunglasses. Once he learns about what happened to Ryan and where it happened, you're going to hear from Mr. Blair. He immediately knows that might be something that the police need to see, and he returns it to them immediately. Because, hey, who knows? Maybe it was just a random pair of sunglasses, but maybe it's important to police. Another person you're going to hear from, another regular citizen, Seth Kaufman, now living in Tampa, coming back to Palm Beach County to tell you what he saw in those early morning hours. He's going to tell us that he lived in Mirabella, a neighborhood just west, about 3.5 miles of where Ryan was found. He's going to say that he, too, going out for his morning run, early morning hours. And he's going to say he saw something out of the ordinary when he was leaving his neighborhood. That when he was leaving, as he's turning onto Jog Road, he sees a black male, disheveled, wearing dark clothing, and a backpack on. Now, he'll tell you, he only looked at him for a few seconds, didn't get a really good look at his face, and by the time when he's passing that man and kind of looks back to get a second look, the man's not there anymore. A random occurrence, not really anything out of the ordinary, but again, when he hears what happened to Ryan, he makes sure that law enforcement knows about that detail. Maybe it's helpful, maybe it's not, but better to say it than keep it to yourself. And that's what he's going to tell all of you when he comes in here. Detective Brashear then starts scouring the area, looking for any and all surveillance video that can, number one, show Ryan's pathway as best as it can, but primarily, can it show the man or woman that did this to Ryan? So she's going to testify about all the surveillance video she was able to compile. You'll see that surveillance video, not only once it's introduced by her, but through Colleen Machado, who put together compilations of all the surveillance video that was obtained in this case, showing not only Ryan, but also this defendant's movements. So surveillance video is obtained. You'll hear from the crime scene investigators that they swab everything for DNA, knowing that, hey, if we get a suspect, we can compare that suspect's DNA to any DNA found on vital pieces of evidence. And so they, through their investigation, after getting surveillance videos, after getting tips, after going out and doing all of this investigating, that they're able to center on a suspect, a person of interest. That person of interest is him right there. So what we're going to learn from Detective Brashear is that she's able to work with the Miami-Dade Police Department to obtain not only a search warrant for this gentleman's DNA, for his personal belongings, and for his cell phone, to be able to search those things and see if there is anything tying this man to Ryan's murder. But what we're going to learn is you got to find the defendant first. And you're going to hear from the cooperating detectives down in Miami, one like Detective Grossman, where he says once he's contacted by Detective Brashear saying, hey, we think he's located in Miami because we know that he has a YouTube channel. And on that YouTube channel, he will post videos. And based on what we're seeing in those videos, it looks like he's in somewhere in Miami to us. So you'll be able to hear from Detective Grossman. You'll hear that on November 26, 2021, he is starting to look for this defendant down in Miami. In the afternoon hours, he is able to see that this defendant posts a YouTube video that has kind of distinctive things in the background that maybe somebody familiar with the Miami area would be able to recognize where that video is. And we'll learn from Detective Grossman that after cooperating with some fellow officers, they say, yeah, we know where that is. That's Gibson Park in Miami. And lo and behold, when Detective Grossman goes there, along with other assisting officers, who does he see sitting on a park bench? This defendant. Backpack, cell phone, and all. We're going to hear from them. That they approach Mr. Williams. They ask him if he would speak with them about their investigation into Ryan's death. We'll learn that this defendant agrees and goes back to the police department. We'll learn from the detective that this defendant is asked, did you have anything to do with Ryan's death? This defendant's answer, absolutely not. Don't even know who that kid is. Okay, well, armed with the DNA search warrant, armed with the cell phone warrant, armed with the personal property warrant, they take those things and retain custody of those items to do further investigation. The defendant is not arrested on that day because at that point, he is still just a suspect. But what we are going to learn from our DNA experts, from our detectives, that when they start looking at his cell phone records, it shows a man that on November 15, 2021, in the morning, started in Miami, used the Tri-Rail, and made his way to this county, made his way to Palm Beach Gardens. And that in the early morning hours of November 16, 2021, he heads right back down to Miami. Did a lot in a little bit of time. And because we were able to obtain his DNA from him himself, and when the DNA experts testify, they start comparing his known DNA to the possible DNA samples found on various pieces of evidence, what that DNA expert is going to tell all of us is that the sunglasses that were found in the same area where this horrible event occurred, his DNA on it. Where the bicycle was found, you're going to learn that there was a set of headphones kind of trapped in the back wheel of that bike. Tested that for DNA. Guess whose DNA was on that? Right there. They tested the fingernail clippings of Ryan, his left hand. The medical examiner will talk to you about why they do that, and the DNA expert will talk about what the results were. On Ryan's left hand, guess whose DNA is trapped in those fingernail clippings? Right there. And lastly, the backpack that this gentleman had, that Mr. Kaufman saw, that disheveled man with a backpack in the same area where this occurred, when they look in his backpack, they find a camouflage bandana. On that bandana, they see things that immediately look like blood-like stains. They swab those blood-like stains. Guess who? 2 people DNA were on that. His and Ryan's. Armed with all of that. That he was where it occurred, that he has his DNA everywhere on the crime scene and in his own bag of a person he said he never met. We're going to learn from Detective Brashear that she gets an arrest warrant for first-degree murder. And on December 1st of 2021, they relocate this defendant and place him under arrest. And when they do that, not only does he know that he's charged with murder, he admits to doing it. That is what we anticipate the facts and the evidence of this case will show throughout the next several days. And so what we ask is that take any notes you need. Please listen intently, as we know you will. And please remember that we have to meet our burden, but not more than that. We do not have to prove this case beyond every type of possible doubt, every type of imaginary doubt, every type of forced doubt or speculative doubt that you may have. It is just beyond every reasonable doubt. And our position is, by the conclusion of this trial, when you have a chance to go back in that jury room, finally talk amongst yourselves about all of the facts, evidence, testimony, exhibits that we present to you, there is only one reasonable conclusion about Ryan's death. And that reason is, on that day, this defendant decided to randomly attack him and end his life with no legal justification to do so whatsoever. So that's why we'll ask at the conclusion of this trial, you check the box that marks guilty of first-degree murder with a weapon. Because Ryan is dead. He's dead because of this defendant. This defendant thought about it and then did it over and over and over, and he did it with a weapon. That, ladies and gentlemen, is first-degree murder. Thank you very much.
Thank you, Mr. Clausey. Does the defense wish to give an opening statement? Ms. Gashery, are you giving the opening statement? You may proceed.
Targeted tracked, and tormented. Mr. Williams lived majority of his life being gang-stalked by an organization that had ties to every major organization, including law enforcement. And that he believed he was a targeted individual, which led him to being tracked and tormented by this organization. And in this trial, you will learn what that means, and specifically what that means to Mr. Williams. Mr. Williams spent the latter part of his life trying to escape this monitoring, this tracking, going from different states to different states, looking for a place of solitude, seclusion, and solace. In an attempt to escape this organization that was gang-stalking him. This became so suffocating to Mr. Williams, he started documenting this harassment and tracking through a YouTube channel he created. Over 300 videos he documented, recounting and capturing what was happening to him. Despite his efforts to get help never came. So he moved from state to state, from city to city, looking for a place of seclusion, a place of rest, a place of escape, but none was found. And on November 15th of 2021, Mr. Williams felt it was time to venture to a new city to try to escape this torment. And you will see videos of him leaving the Miami, Florida Tri-Rail station and making a stop, then ultimately ending up at the last stop up here in Palm Beach County. Walking, you'll see him walking, searching, looking for that place of solitude, seclusion, and solace. And as evening drew near and the sun set, he kept walking, he kept searching, he kept looking for that place. He looked in a wooded area, as you will learn was his custom, to attempt to escape from these tormentors. Because this was his journey, this was his life. And as he walked in a wooded area, he heard something distressing. Not realizing what happened or who it was, he went by a steep wooded area and realized there was an unconscious individual. Unable to see that person's face, unable to see that person's injuries, frankly not knowing what happened to this individual. And you will learn that the area of Central Boulevard at night is extremely dark, and you will see pictures of that. You will hear that even as cars drive by, they are unable to illuminate that path, not able to illuminate that path for Mr. Williams to see, for anyone to see for that matter. But unable to assist that individual and still on this journey of escape from his tormentors, which included law enforcement, Mr. Williams left. Not realizing that the person that was injured was bleeding, not realizing that his headphones had fallen, and not realizing that person was a child. Yet, in order to continue trying to find that place of solace, Mr. Williams left that area, looking for that place of solitude and seclusion, which he never found. Members of the jury, there is simply not just one way to look at the evidence in this case, as the government would have you believe. And as the government provided their view of what they believe happened in this case, in order for that to be true, they must provide evidence that provides proof beyond and to the exclusion of every reasonable doubt. And members of the jury, they will not be able to do that because the evidence in this case is circumstantial And the circumstantial evidence in this case has another view, another innocent explanation. Now, what happened to Ryan Rogers is undoubtedly a tragedy. No one in this courtroom will disagree with that assertion. But Mr. Williams is not responsible for that tragedy. And in order for true justice to prevail, the right person must be accused, and evidence that provides each and every one of you proof beyond and to the exclusion of every reasonable doubt be provided by the government. And again, they will not be able to do that for you, members of the jury, because Semmie Williams is not guilty. Thank you.
Thank you, Ms. Gowshery. State, please call your first witness. You may.
Judge, at this time, the state called Cynthia Rogers.
Ma'am, once you're comfortably seated, pull the mic close to you. It pulls from the base. Say your first and last name, and spell both names, please.
Cynthia Rogers, Cynthia Rogers.
Thank you. State, do you wish to inquire?
I do.
You may
thank
proceed.
Good morning. Miss Rogers, who is Ryan Rogers to you?
My son,
Okay. Back on November 15th of 2021, where were you living?
Alton,
And is Alton in Palm Beach Gardens?
yes,
Okay. Is that like a residential area?
yes.
Okay. Who lived there with you?
My son Ryan and my son Justin,
Okay. Did Ryan have a bicycle?
yes,
Did he go for a bike ride on November 15th of 2021?
yes.
Okay. Was this something that he did often?
Every night,
Every night? Okay. What time were you expecting him home?
no later than 9.
Okay. 9 o'clock comes around. At some point, did you realize he wasn't back at the time you expected?
Yes,
Okay, so when you realized he wasn't back, what did you do?
I started calling him and I went outside to look down the street to see if he had met up with some kids at the park down the alleyway.
Okay.
But there was nobody there. So,
At any point, did you actually leave your house to kind of
yes,
look around?
I drove around looking
Okay.
for him.
When you didn't find him, did you ultimately come home and call law enforcement?
Yes, I called them.
Okay. Law enforcement come to your house, take a report from you?
They did.
Did you also do anything else so you could kind of speak to your community to give them information about Ryan not coming home?
Around 3 a.m. or so in the middle of the night, I did a post on Facebook on my personal page and on the Alton Facebook page
Okay.
saying that he was missing and if anybody had seen him.
Okay. And did you post that out to as many people as you could reach?
Yes.
What time on November 15th did he leave the house?
Around 6:40
Okay. How did you know what time he left?
because on the camera and the Arlo camera behind my house, it shows him leaving on his bike.
Judge, at this time, the state would move into evidence, I believe by stipulation, State's Exhibit 1, the video from the residence.
And Exhibit 1 admitted without objection.
I have no further questions. Thank you, Ms. Rogers.
Cross? Ma'am, you are free to step down. Thank you. Next witness.
The state calls Todd Blair.
Sir, once you're comfortably seated, pull the mic close to you. It pulls from the base. Say your first and last name and spell both, please.
I'm sorry.
And spell both names, please.
Todd Blair, Todd Blair.
Thank you. Do you wish to inquire?
I do, thank
Please
you.
proceed.
Good morning, Mr. Blair.
Good morning.
We're going to jump right into it, okay? Back in November of 2021, where were you living?
I lived in Paloma, 12281.
You don't have to give your
Yeah, you-
address. You don't have
just-
to give your address, just the city.
Thank you.
Thank
So
you.
let's talk about Paloma. What city is Paloma in?
Palm Beach Gardens.
Okay. How close is Paloma to the Alton area?
To Alton,
Yeah.
within a half mile.
Okay. Were you out on Central Boulevard on November 16th of 2021?
I was.
Why were you out on Central Boulevard?
I was out for my morning run.
Okay. When you say morning run, approximately what time were you out?
So I run 3 days a week, and this is a couple of years ago, but usually between 6 to 6:30, I would be starting my run. Going
Okay.
over Central Boulevard.
Would it be fair to say around dawn, like as the sun's
So
coming up?
At first light.
Okay. So I want to talk about that area of Central Boulevard. Is there a part of Central Boulevard that actually has an overpass over I-95?
Yes, that's rounding out of my community, coming around the quay, and then up and over the bridge, the overpass of 95.
Okay. When you are on your run, going over that area, did you find something unusual?
Yes.
What did you find?
That morning, I was coming over the bridge, and as I passed over 95 on the south side, heading towards PGA Boulevard, I passed a pair of sunglasses on the floor.
Okay. When you say on the floor, like on the sidewalk?
Yes.
Okay. Where, like, let me see if I can ask this. Was it in the middle of the sidewalk, in the grass? Like,
No, it was right in the middle of the sidewalk, all right? The sidewalk's maybe 4 feet wide. It was within the first 2 feet on the left side.
okay. What did you do?
I actually passed them. I turned around and picked them up and looked at them quickly. It was still dark, and put them in my pocket and kept running.
Okay. This time in 2021, around COVID times? Is that yes?
Yes, correct.
Okay. Did you do anything with it? Well, did you finish your run?
I finished my run. I might have stopped at the water fountain. I can't recall, which is halfway in my run. I looked at the glasses. I thought they might be scratched. I thought there might be a pair of Oakleys, so worth keeping. We find a lot of stuff on the road. I couldn't tell if they were scratched or not. Definitely recall spitting into the glasses. I might have rinsed them off at the fountain, but I don't recall if I did. But I do recall definitely spitting into them to see if they were scratched or not, worth taking them back on my run.
Okay. At this point, when you're on your run, did you know anything about a missing child in the area?
No.
Okay. So once you get home, what do you do with the sunglasses?
I take off my sneakers and the glasses. I put them in my shoes outside my front door, and I walk into my house.
Okay. At some point, did you become aware of police activity in the area where you found the sunglasses?
I may have noticed. A helicopter flying over me, and I'm not sure. It was a lot of years ago.
Well, at some point, did you call the police to tell them about the sunglasses?
Yes.
What made you call the police?
When I came in, my wife was making coffee, and she told me that.
It's effect on the listener.
Approach. Sustained, please rephrase.
So, Mr. Blair, did your wife notify you that somebody was found in that area?
She did.
Okay. Once you had that information, did you call police and give them the sunglasses?
I did.
Okay. Did you tell the police about, that you actually spit in the sunglasses?
I did. I believe I'm fairly certain I did.
Okay. Judge, may I approach the witness?
You may.
I'm approaching you with what has been marked for identification as states 2A. Do you recognize that?
These appear to be the glasses that I found.
Okay. Is that a fair and accurate depiction of the sunglasses that you found on Central Boulevard?
Do you have a second picture which would show the side?
Can I retrieve the other?
Yes.
So, Mr. Blair, I'm going to show you 2A through J. You have A there.
Yes, this would be them.
Okay. And
I
is that a
remem- I-
fair and accurate depiction of those sunglasses?
Yes, I remember seeing the insignia and I couldn't tell if that was Oakley, which was made me carry them, but they weren't.
Okay.
Mm-hmm.
Judge, at this time, the state will move into evidence states exhibit 2A through J. No objection.
2A through J admitted without objection.
May I reserve publishing?
Yes, ma'am.
I have no further questions. Thank you.
Cross? Sir, you can step down. Thank you. Counsel approach. State, please call your next witness.
The state calls CSI Paige Cohen.
Yes, I do. Ma'am, once you're comfortably seated, pull the mic close to you. It moves from the base. Say your first and last name. Spell both names, please.
My name is Paige Cohen, Paigecohen.
State, do you wish to inquire?
I do.
Please proceed.
Good morning.
Good morning.
So you've already introduced yourself. Where do you work?
I work for the Palm Beach Gardens Police Department.
And what do you do for the Palm Beach Gardens Police Department?
I am a crime scene investigator and a latent examiner.
Okay. Let's talk about the first one, being a crime scene investigator. What is a crime scene investigator?
I am responsible for responding to crime scenes. I take photographs I document the scene, I collect evidence, I prepare sketches, and I also process evidence.
Okay. And we'll talk about what processing evidence means when we get to that portion. But what kind of background do you have that allows you to do that job?
I've been a crime scene investigator for approximately 35 years. When I graduated college, I was hired by the North Miami Police Department. I was there for 23 years. I retired. I have a Bachelor of Arts in Anthropology and Sociology with a minor in Criminal Justice. I have over 1,500 hours of crime scene training in photography, evidence collection, evidence processing, especially in fingerprints and DNA. And I'm a member of 3 forensic associations, including the International Association for Identification. And as of October 2025, I am the crime scene unit supervisor.
Okay. Were you called out to the scene of a death investigation on November 16th of 2021?
Yes, I was.
Can you tell us what time were you called out approximately?
Approximately 9 a.m.
Okay. So daylight.
Yes.
Where was the scene?
It was in the 12300 block of Central Boulevard.
Okay. So I want to talk a little bit about that area. What kind of road is Central Boulevard?
So Central Boulevard is one of the main roads in Palm Beach Gardens that travels mostly north and south. It is curved. And the location I responded to, it actually curves a little east when it hits or intersects with I-95.
Okay. At any point, does Central Boulevard actually go over I-95?
Yes.
So would Central Boulevard be, I just want to make sure we're describing this correctly. So Central Boulevard has an overpass over I-95. I-95 is underneath?
Yes, it's a covered overpass.
Okay. Where exactly we're going to look at maps in just a moment, but where did you respond on Central Boulevard?
I responded on the east side, about the 12300 block, which is just south of that intersection at I-95.
I'm showing you what will be marked for identification purposes as states 3A and B. May I approach the witness?
Yes, ma'am.
Do you recognize those?
Yes, I do.
Okay. And are those kind of a wide map and a narrow map of the area of the crime scene?
Yes, they are.
Okay. Judge, at this time, the state would move into evidence states 3A and B. No objection.
3A and B admitted without objection? Yes. Ladies and gentlemen, we're going to take an early lunch break to address some technical issues. The lunch break will be about an hour and 15 minutes, so I'm going to ask that you come back at 1:45. Enjoy your lunch break, but no texting, tweeting, blogging, emailing, sending or accepting messages, communications of any kind about this case or your jury service. Deputy Francis will show you out the back way and tell you where to meet so that we're all here at the same time so we can start and resume testimony. Enjoy your lunch break. Ms. Cohen, you can step down and enjoy your lunch, but there is no discussion concerning your testimony, okay, ma'am? Yes. See you back here at 1:45. You all can be seated. Madam Clerk, can you call IT? Thank you very much.
Thank
Do you want to address the evidentiary issues now, and then we can break for lunch, and then you can come back at that time? All right. Can I have what it is that you are asking me to consider?
Sure, I think. Can we approach?
Yes, please. There's an objection to this? Uh-huh. Do we need, we're doing this on the record. Okay. So the defense has an objection to what is to be marked as, doesn't have
It
a,
doesn't have a number, Judge. I will supplement the record when it's numbered. It's just, I didn't number anything because I wanted to make sure I knew what was going in.
okay.
Obviously, the court.
We need Mr. Williams to be able to hear what's going on, so why don't we get handheld mics so you can be close, but so Mr. Williams can hear. Ms. Walensky, so the record is clear, I would ask that you mark it as something, even if it's not yet admitted, so we can all know what we're talking about.
We can just make it 4. I'll just go.
All right. I'm going to have you mark it on here as 4, and then Ms. Gasgery, which of the letters in Exhibit 4 are you objecting to?
Can I
Let-
approach to do that?
Yes, please.
Letters A.
You can come up to the bench, so we're all, so we can all see each other. I just needed you to speak into the mic so
okay.
Mr. Williams can hear what's going on.
Okay, so that would be letters A, like Alpha, B, Bravo, and C, Charlie.
A, B, and C.
Yes.
Those are the ones you object to.
Yes, Your Honor.
And what's the legal basis for the objection?
In all 3 photographs, there is that pink paper that has the writing with Mr. Killer on it.
Okay.
We would, have a relevance objection, and even if deemed relevant, we would have a 403 objection because there is no probative value. There's no time frame in when that notation was made, whether that was made by Mr. Williams, how it even got there. So it would lead to confusing the jury and an improper inference, which would be prejudicial.
So I have relevance in 403. Response?
So the relevance is that it was found on the defendant when he was arrested. So that would be the relevance. And it's not just that it says Mr. Killer, it says I am Mr. Killer.
It says Mr. Killer is my name.
I'm sorry.
Okay.
Semantics, but Mr. Killer is my name. It's akin to an admission
Okay.
in a homicide case when he's been arrested for homicide.
So you're saying it's both relevant and not confusing or otherwise prejudicial.
Correct.
Any further response?
And just as to admission, that I would be arguing again, there's no time frame in which that notation was made, who actually made that notation. Although it is among his property, there is a lot of other miscellaneous documents.
Doesn't that go more to the weight of the test of the evidence as opposed to its admissibility?
I do believe that it would confuse the jury, as it could be improperly argued that it is an admission, which there would be no other evidence supporting that assertion. But other than that, that is my objection.
Mr. Williams wants to talk to you.
Me? Mr. Williams would just like to address the court as to that specific.
He has counsel, so no, I'm not going to have him address the court at this time. He can speak through you.
Yes, those are defense objections.
Okay. Any further argument concerning 3A through
A, B, and C.
3A, B, and C?
No.
The objection's overruled. The court finds that the photographs are both relevant and there is the probative value outweighs any prejudicial effect. The court finds that the evidence, that the defense's arguments goes to the weight of the evidence, not its admissibility. And the court is permitting those exhibits to come to be admitted in evidence over the defense objection. Any other issues to address before we break for lunch?
Yes. So, for purposes of this argument, the state will, I think I'd like to label these as a court exhibit. I will supplement the record with what they will be labeled, but I will have to relabel everything if they're taken out. So I just want to make sure. So I think we'll call this court exhibit 1 for now, and then we'll rename it if the court allows these photos so that the record is clear.
Okay, I thought I just allowed the photos.
No, this is, I'm
Another
talking about
set.
the next one. I'm sorry.
Okay,
No, the one that we just talked about will remain for A through.
okay.
So. for
So
court-
there's still a court intervention necessary for another court exhibit?
Yes.
Okay, what's that? And that's the one you're labeling Court Exhibit 1?
Yes.
Got it. Go ahead.
Because I don't have another way to do it. So I pulled all the pictures with him in it, so she can see
Okay.
what they all are, and you can say your judgment. I know you're not objecting to all of them. But I
Yeah.
thought she wants to.
So these 3, which I don't know the number, or 4.
You need to mark them. Why don't we do this? Why don't I let you all get all that together, and then we'll address this, come back at, I said 1:45 for the jurors? Yeah, so come back at 12:30.
I know Mr. Williams would like to ask the court a question. I'm not sure what it is.
So, Mr. Williams, let's get a mic to you.
Okay.
As you may recall, during the jury selection process, there was a lot of interaction between you and me, but that was
Right.
outside the presence of the jury. Going forward now that the jury is actually sworn, the interactions need to go through your attorney. Okay?
Yeah, but my attorney, like I said before, my attorney doesn't listen to me and tells me false information a lot. So that's the reason why it's a problem. So when she tells you something, can you just confirm whatever she said to you so I know?
Well, most of the discussions we're having are in open court. So at this point, there hasn't been any discussions that you have not been listening to and a part of.
So what? So see, when she goes to me and she tells you things, I don't know what she's saying, and they have a history of just telling me false information. So that's why I would like you to just tell me whatever they said.
Okay. I'll try my best to try and accommodate the request. However, some of the discussions, as I said to the jury, has to occur outside of everybody's presence. So it's administrative issues. If there's any substantive issues, we'll certainly make sure that that is done in open court, like we're talking about with these exhibits, right? So you heard what the issues were with the exhibits, and you could speak to your attorneys and tell them any issues that you have with them, okay?
So how do I know that she's telling you how do I know that she's saying what I asked her? If she's not saying it loud, I don't know what she's telling you.
Sir, as it relates to the admissibility of evidence, I will do my level best to make sure that you hear what those issues are, so that if there is a concern that you have, you can relay it to your attorneys, who can relay it to me.
Okay. Did she tell you what my objection to the photo was?
They articulated a legal objection, yes.
Oh, well, my objection was I never knew Ryan. I never seen him in my life. So
See, this is the reason why you can't speak, because now you're sort of that's the reason why you're attorneys. So there was a legal objection. The legal objections that your attorney stated, which I know you heard, was that it is more prejudicial than probative and it's not relevant. Ms. Gashery also indicated that there is no confirmation that the writing on that piece of paper was yours. And I ruled that the evidence is admissible, that her argument goes to the weight of the evidence, so the jury can consider the weight of the evidence, not its admissibility. Okay?
Okay.
Okay. Ready to break for lunch? Yes. I'll see you at 12:30, right, counsel? Yes. Thank you. I think Ms. Walensky's going to figure how she's going to label it and then let you know so we can update the records. It's important that is done, Ms. Walensky.
Stickers, so that way I can just put a new sticker over it.
That's fine, but it just needs to be done for the record.
I'm